Hello everyone. Today we will be presenting the Supreme Court case Lemon v. Kurtzman by Skylar, Kane, Nicholas McConnon-Shahin, and Kaitlin Morgan. Context. Setting the scene, the law in 1968, Pennsylvania made the Non-Public Elementary and Secondary Education Act of 1968. This law funded religious schools, teachers, books, and materials. The superintendent of the school district had to approve all courses to make sure that they were not funding religious teachings. First, Alton Lemon, a taxpayer whose child attended a public school. Second, Lemon felt like the law was unjust and made a civil lawsuit against David H. Kurtzman, the superintendent who was supposed to administer this new law. Third, the case was brought against the district court and they sided with Kurtzman. Lemon did not like the ruling and appealed to the Supreme Court in 1971. Let me move myself over here. Standing, Lemon sued Kurtzman on the basis that he was funding religious schools through his tax dollars, and that goes against the Establishment Clause in the First Amendment, which states that this government cannot establish a religion. Stare decisis. There are three cases that could set precedent for this case, and there are two that go against it and one that supports it. Everson versus the Board of Education, 1947, the Supreme Court majority opinion declared at a law in New Jersey that reimbursed parents for busing for religious schools from tax money was constitutional. Then two of them that went against it is DeSanto versus Robertson in 1970. The Rhode Island District Court declared a law in Rhode Island that supplemented 15% of non-public school teachers' wage for non-religious classes to be unconstitutional. And the third case is McCollum versus the Board of Education. In 1947, the Supreme Court majority opinion declared a program in Illinois that allowed public schools to have religious instruction to be unconstitutional. And now on to Skylar.
All right, so now on to the constitutional question, which is, do certain laws that allocate state funding to religious non-public schools violate the Establishment Clause of the First Amendment? So we're going to dig into that with the court's majority opinion. So first, Justice Warren Burger explained that religion must be a private matter for the individual, the family, and the institutions. So this is helping explain that religion needs to be an individual decision and there shouldn't be any government involvement in it. So when we talk about majority opinions, we have the court's majority decision, which was 8-0, reaffirmed the district court decision with Justice Thurgood Marshall not voting. It established that the law presented in the state of Pennsylvania regarding funding to private religious schools was unconstitutional on the basis of the Establishment Clause of the First Amendment. Now, the second majority opinion was 8-1, which agreed with the district court in Desenso v. Robinson and established that the law presented in the state of Rhode Island regarding settlement of wages to private religious schools was unconstitutional on the basis of the Establishment Clause of the First Amendment. So Chief Justice Warren Burger also said that the laws resulted in excessive entanglement between government and religion, which would set the stage for the Lemon test, which is established at the end of this case. Okay, so for voting block, who voted that these laws were unconstitutional? So we have Chief Justice Warren E. Burger, William O. Douglas, William J. Brennan Jr., Justice Potter Stewart, Byron R. White, Justice Thurgood Marshall, Harry Blackmun, Hugo L. Black, John Marshall Harlan. So we can see the president who appointed them. We have a mixture of Democrat and Republican presidents, and Justice Thurgood Marshall did not vote for the Pennsylvania law, but he did for the Rhode Island law. And Justice Byron R. White was the only one who said no to the Rhode Island law being unconstitutional. Chief Justice Warren Burger also said the people who were confronted with issues of this kind will find their votes aligned with their faith. So this is what he was worried about and why he didn't want religion to be entangled with government.
Short-term impacts. Right away, many state funding measures of non-public religious-based schools were revoked as a response to the court case. This left many schools in a vulnerable position and had to figure out new ways of funding themselves. These states immediately had a change of social climate, meaning new conversations arose about the mixture of government with religion and religious education. Long-term impacts. The Lemon Test was a result of this court case and set a precedent for any new court case involving the Establishment Clause of the First Amendment. The Lemon Test contained 3 different criteria that would help future justices determine if a law is unconstitutional or constitutional on the basis of the Establishment Clause. The Lemon Test. The 3 criteria of the Lemon Test go as follows. 1. Secular purpose. Laws must be non-religious. 2. Primary effect. The main effect of the law must not prevent or advance religion. 3. Excessive entanglement. The law must ensure that the relationship between government and religion is non-existent. This establishes that government should not involve itself in religious debates. Concepts. Protects the minority. The Lemon Test aids in safeguarding the rights of religious minorities by ensuring that the government does not unduly favor one religion over another. Strict constructionism. The court's decision on this case was based on the interpretation of the Establishment Clause according to its original intent and meaning. The court sought to ensure that government actions regarding religion adhered to constitutional language. Judicial restraint established a 3-pronged test in order to guide lower courts in decision-making regarding laws about religion, rather than imposing its own policy preferences. This allows the court to set clear standards while also respecting the role of the legislative branch. Unfavorable towards state governments. The ruling limited certain state actions regarding government aid to religious schools. Brutus would be unhappy that the Supreme Court has extreme leeway in determining what constitutes a secular or religious law.